As a PhD student who actually did family law, let us talk about the grounds that can guarantee or that qualifies a person to bring a petition to dissolve a marriage under Nigerian legal system. So we were in class, and then after looking at these grounds, the lecturer was like, "Are these typical of African society or African culture? If these things happen in our system, can it actually be a ground, or are we talking about um, updating our laws with respect to matrimonial proceedings?" So let's look at it. By the time you finish looking at it, you'll be the judge, and I'd like to have your answers, your comments in the comment section. So when you look at section 15 of the Matrimonial Causes Act, which is one of the laws that regulates matrimonial proceedings in Nigeria, you will discover that where a marriage has broken down irretrievably, it is a ground to dissolve that marriage. When you say broken down irretrievably, you're saying that the marriage has broken down beyond repairs. You can't fix it. It is spoiled. It is damaged beyond good. You can't. There's no good that can come out of it again. That is a ground. Beyond that, you also see that where the respondent, for your information, is that person that you are bringing to court, who you feel that this person has wronged you as a partner, so you don't want to continue with that relationship. So you now see that the respondent has willfully and persistently refused to consummate that marriage. They cannot come together as husband and wife. Willfully and persistently, nobody is forcing. Why? The respondent has refused to consummate the marriage. Now, the listing these grounds is what makes our divorce process fault based. It is false based because you have to prove these grounds that they exist so that you can convince the court to grant you the relief that you are seeking for. Unlike other jurisdictions that do not operate this fault-based system, once you come to court in those jurisdictions and you just tell the court that, look, no, 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 we are done, we can't fix this, broken down, the court will just grant the relief. Okay. Now it is fault-based because of the enmity it creates between married parties. You have to fight. Some people fight so dirty so that the court can deem them fit to get the relief that they are asking for. So where the person willfully and persistently refuses, it is a ground to dissolve a marriage. But note that this incapacity to consummate a marriage, the court will look at it very well because it is a ground that is already making a marriage voidable. There is no need granting the decree of nullity. When you look at section 36 of the act, you understand what I am saying. The court will not see it as necessary anymore to do what? To grant what? The decree of nullity, if it is only seeing it that it is voidable. Unless, in the opinion of the court is now saying that, okay, at the time when this proceeding commenced, this incapacity was already existing there, was in existence. You're bringing a petition to court today to dissolve your marriage. The court now sees that as at today, when you are bringing this petition, this incapacity is still there in existence. And that this incapacity is incurable. There is no cure anywhere in the world. There is no cure for it. At that point, the court can actually declare or decree what you're asking for. Or now that you have now discovered it and you see that there is a cure, the respondent has refused to submit himself or herself to medical examination. Like in some cases, the person will refuse to honor medical appointments. There is nothing you would say or do that the person will go to the hospital to see a doctor to be properly examined. Or in some cases as well, the person may go to the hospital but has not, the respondent may go to the hospital but has now refused to submit himself or herself to medical examination. In such a case, the court will not look away. Now, if you, that is the petitioner that is bringing this petition before the court, you now look at the court now looks at it and says that yes, you already have knowledge of the existence of this incapacity from the beginning, court will not answer you. Hmm? Court will not answer you. So these are grounds. This is one of the grounds for the dissolution of marriage. Now, this one is in section 36. So let's go back to the original place where we are talking about the grounds. So another one is that since the marriage, the respondent has committed adultery and the petitioner finds it intolerable. No, 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 I cannot bear with this. In Nigeria, for instance, the country where you and I live, is this enough grounds for dissolution of marriage? Because a lot of things go on in marriages and women just continue to deal with it, to live with it. But on the other hand, if the woman becomes the respondent in the case, the man would not want to go on with the marriage. So if it gets to that point where the man now says, no, 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 and meanwhile, if you actually go to the Bible says this is the only ground where a man can put his wife away when the woman commits adultery, not the other way around. It is not the duty of the woman to put the man away because the man committed adultery, right? It is biblical. If God wanted a woman to put his man away because of adultery, I'm sure the Bible will also have stated it. Okay, so though the law is more flexible, both men and women can choose, if they cannot tolerate it, to put the other person away. That is the second ground, okay, for dissolving a marriage. Or you see that the respondent has behaved in a particular way that reasonably the person who is bringing the petition to court, nobody will expect him to reasonably continue to live with that respondent. Now, in explaining this paragraph C, where behavior becomes the issue or the ground, a kind of behavior that the petitioner is not expected to continue to cope with, you don't have to understand it better. You don't have to go over to section 16 sub 1 of the act. There, that is a supplementary provision to section 15 of the Matrimonial Causes Act. So if you're bringing a petition for dissolution of marriage before a Nigerian court, and you're coming under paragraph C of section 15, you will have to look at the supplementary provisions to section 15 that is made under section 16 of the Act. So to be able to prove this point, you must satisfy the court of a list of things, which is maybe the respondent has committed sodomy, has committed rape, has committed bestiality, or has been for a period of not less for a period less than 2 years, has been a habitual drunkard, intoxicated by reason of um alcohol, any other substance, So these are grounds step by step how you can actually bring a petition for the dissolution of marriage under Nigerian legal system. So this is not all the grounds. So I just took like 3 grounds I just took like 3 grounds. Yeah, if you want. Furthermore, if you also look at paragraph D of that section 15 sub 2, you also see that where the respondent has deserted the petitioner for a period of 1 year preceding the petition, or both have lived apart for a period of 2 years, and the respondent does not actually object to a decree being given. They have lived apart from each other for a period of 2 years, and the respondent doesn't care. If you want to give a decree, please go ahead and give it. Let us go our separate ways. If that is the case, it's also a ground to bring a petition to dissolve the marriage, or both have lived apart for a period of 3 years preceding the commencement of the petition to dissolve the marriage, or there has been an order of restitution of conjugal rights which they have failed to comply with, or one of them has been absent for a period for a very long time. Now, to understand this part, you have to go to the criminal code. That is why I always say that no branch of law stands alone. So when you look at the criminal code, you will now discover that absence has been construed to mean a period of 7 years. So when that respondent has been absent for a period of 7 years, can be declared or presumed dead. And once it's presumed dead, the court can go ahead to grant that decree. Okay, the court can go ahead to grant the decree. So these are grounds that can do what somebody can experience or see in existence, and then you can say, okay, let me bring a petition to dissolve this marriage. So like I said earlier in the previous video, with respect to paragraph C of section 15 sub 2 that relates to behavior. Now, to bring an action under this section, this paragraph C, section 16 of the Act has now made provision of a list of activities that can qualify you as a person, things that you can prove as behavior. Like I said, being a habitual drunkard, um, living under intoxication over a period of 5 years, or for a period of 5 years, has suffered the frequent convictions as a result of the life the person is leading, is not a straightforward person, one court case or the other, convictions and all that. He just intentionally, habitually, he just leaves the home without making a means available, does not care, leaves the petitioner to sort himself or to sort herself out. There's no provision as to means, there's been a conviction for a period of 5 years, and it's still, and he or she is still in prison. It is also a ground to use, you can use to prove paragraph C that I talked about before, intentional infliction of grievous or bodily harm. Some people, when we talk about domestic violence, when a partner will beat and beat you to the point that you're already passing out, or sometimes the person even passes out. Some people will talk about very lethal weapons and all that dangerous weapons that the partner can use on the other. That is also a ground threatening to kill the person. It is also a behavior that you can also prove under paragraph C of this act. Then you can also prove the unsoundness of mind of that respondent. This unsound, the person is of unsound mind. Under our laws, person of unsound mind is not capable to enter into any contractual relationship, and marriage is also a contract between two adults, a man and a woman. So if the person is of an unsound mind and there is no reassurance of recovery, you can also prove that under paragraph C. Okay, you can also prove that under paragraph C and many other grounds that you can use if you want to come before the court, using paragraph C of section 15 sub 2. I hope this helps someone out there. Yeah, this is Xavier Law Essence. This is where we give you premium legal tips to help you make informed decision, live informed life, and discover the very best version of yourself. Okay, we'll see you again. Bye.